I just click go live. It'll be a moment. The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon, gentlemen. Thanks for joining me. I apologize again for being late. That's all on me. This is Single Justice Matter 2020 J0533. Can counsel state their appearances for the record?
Good afternoon, Your Honor. Mark Gould for the Taunton City Council.
Good afternoon, Your Honor. Richard Burke for Basque Inc.
Okay, good to see you guys. I have a few questions about this, some of which I've already indicated to you what they are. So hopefully you've had a chance to marshal any additional information that you want to provide me. I will have a lot of questions. So don't be surprised when you're interrupted. Mr. Gould, it's your petition, so why don't you start?
Thank you. May it please the court. This injunction that was ordered on November 4th enjoins the city from issuing all recreational marijuana licenses. And by way of background, there are 5 marijuana licenses total that the city is authorized to issue. 1 has been issued, so there are 4 remaining. So
I've read all the papers. I understand the case, I think, pretty well at this point. So you can jump right to the heart of your argument.
Essentially, we're asking the court to annul the injunction because the land court doesn't have jurisdiction over the licensing component, as the court indicated was interested in. The authority the city relies on is the limited jurisdiction of the land court, Chapter 185, particularly Section K, which circumscribes the authority to basically any land-related complaints relating to right, title, or interest in land.
Do you have a particular case or two that you want to refer me to?
I would highlight the Karstensen case and the Johnston Products case.
Are they both cited in your brief?
They are. We're on page 5 of my brief, and that has both the Karstensen case and then the Johnston case is on page 7.
Got anything more recent than 1981?
I mean, essentially, the land court cases have followed that jurisprudence and haven't heard anything outside of that scope since. There was one recent case. This is from 2016. It's Landing Group, and that's a land court case. The site I have is 24 LCR 235.
All right. So I understand the argument, and I want to just go to Mr. Burke. And Mr. Burke, why do you think the land court had jurisdiction to enter this injunction?
Your Honor, the land court has equity jurisdiction in this matter. I believe that the statutory source of that jurisdiction can be found at Chapter 185, Section 1, subsections K and P. Subsection K of Chapter 185, Section 1 states that the land court has jurisdiction in all cases and matters cognizable under general principles of equity jurisprudence where any right, title, or interest in land is involved, including actions for specific performance of contracts. And then subsection P states that actions brought pursuant to the provisions of Section 7 and 17 of Chapter 40A. And then— All right,
so the land court has, I'm going to ask the questions. I thank you for the beginnings of this, and we'll talk about whether you got any cases that help you. But let's start with 40A. Clearly, the court had jurisdiction over the claim that you brought.
Yes, Your Honor.
Clearly, the court had jurisdiction to enter enter an order at some point that says City of Taunton had to provide you with a special permit. But you're not asking for a special permit here. You're actually asking for interference in the licensing process. And isn't that separate from the special permit?
I don't believe it's separate, Your Honor, because they're interrelated. And the court heard evidence of this in the trial. The process of opening a marijuana retail store in Taunton is a multi-part process. In order to qualify for the license under the ordinance, you first need to get a special permit. The city council, municipal council, is the special permit granting authority. They're also the license.
I beg to differ with you, but that's not the way I read the ordinance. Maybe that's the way everybody's been reading it, but that's not the way I read it. The way I read the ordinance, it says no person shall operate a marijuana establishment. So a precondition to operation is a special permit. A precondition to operation is also a license. But I didn't see where it said a precondition to getting a license is getting a special permit. Am I missing something?
I read it, Your Honor, and I think the city has argued it the same, as that it's all interrelated. You're not qualified to even apply for a license until you have a special permit, and all candidates have to obtain a special permit, because in any zoning district, there are 2 zoning districts where you can locate a marijuana retail store. In both zoning districts, you have to get a special permit from the city council. You also have to have a host community agreement. You also have to have provisional approval from the Cannabis Control Commission. Until you have those things, you're not even eligible to apply for a license. The license is the final step in the process. That's how it was presented at trial, and that's what the city has argued. And I think that's the meaning of the ordinance. You're not eligible, you can't operate until you have a license. You can't get a license until you meet these preliminary criteria. That's how the city has implied it, Your Honor.
I could see Taunton deciding, under this ordinance to say that we're not going to issue a license until you execute a host community agreement, you have a special permit. But it doesn't say that a special permit is a precondition to the license. Anywhere that I see, it's a precondition to operation. And the only reason that's significant to me is it suggests to me they're 2 different things.
Well, the way that it's been applied by the city, Your Honor, is that these are all steps in the process, and the final step is the license. You have to apply for a license. They have a license application, and you have to demonstrate that you meet all of these criteria before they will consider your license application. So they are, in fact, criteria.
Well, let me ask you this question, counsel. If you got your special permit, it's a hypothetical. Hypothetically, you get your special permit. You go to get a license from the town, from the city. The city says no license. What court can you go to get relief?
I think in that instance, Your Honor, I believe that it would be a petition for writ of certiorari if you were applied for and denied a license by the city council.
And where would the petition for writ of certiorari go? What court?
It wasn't entirely clear to me, Your Honor. It certainly could go to the Superior Court. If it involves a matter involving land, and I would submit that this might, then I think it could also go to the land court.
Help me with the theory under which, in my hypothetical, you could go to land court on the basis that it involves a right, title, or interest in land. Because that's what you would be relying on, section K that you've already cited to me, correct?
Yes, Your Honor. I think it certainly would go to Superior Court as a writ of certiorari, but the writ of certiorari statute seems to say that it could go to the land court if it involves, an interest in land. And this license, again, is related to operation of a real estate. You have to have a place where you operate the license. It has to be a physical location that's approved as part of the license. So in that event, Your Honor, I think it could be argued that it does affect a matter of interest in land. Because to have the license, you have to have a location approved.
Yeah, I understand the argument, and I appreciate it. I'm struggling with it, and I need to sort of. So how do I know? It's almost an argument that says the license. See, the license is going to identify a particular location, right?
Yes, Your Honor.
Is he right about that, counsel?
I know the license refers to the person or the business. I'm not entirely certain it is limited to a location.
Really? I mean, that's your understanding. You're town council, right? City council?
That's correct, Your Honor. Assistant City.
I have a hard time believing after you go through this process that your license isn't just licensing the establishment, but also the establishment at a particular location. No? So once you license the person, they can take it and go someplace else?
You would need to apply for a new license.
Right, because this license is for a particular location.
Correct, for a
particular person in a particular, or for a particular entity or operator in a particular location, right?
That's fair to say.
Your Honor.
Why is that an interest in land? Why is, even if the license is tied to a particular location, it's not title. And it's not an interest in land in any way that I would ordinarily think of it. It's a license.
Your Honor, may I, my
argument.
argument as to the court's equity jurisdiction here, I mean, we are not appealing a denial of a license here. What is being appealed is an issue of a special permit. And what I think one case I would cite you to, Your Honor, is, which is not in my brief, but it goes to the jurisdiction issue, is Ritter v. Bergman. It's 72 Mass Appeals Court 296, 299. And that states that the land court has concurrent jurisdiction of matters cognizable under its general principles of equity jurisprudence. And here, what the court— I don't have any
problem with that. I think that's right.
What the court is doing here, Your Honor, is it's not attempting to rule on a license. The court is attempting to protect its authority to make a ruling, in this case, on a special permit. And what the court is saying is that in order for the court to protect its ruling and give the court an opportunity to make that ruling and make that ruling have meaning, that a temporary stay in the award of licenses needs to be made so that the court will have time to make a ruling. And then if Basque obtains a special permit, it can get in line with all of the other applicants, since they want to award these licenses all at once and have a fair opportunity to be considered.
I totally understand your argument, and I think you understand the weakness in your argument as well. And the weakness in your argument is this: if he doesn't have the ability to affect the license itself, he doesn't have the ability to reach out and tell Taunton to stop issuing licenses. So you say to me, well, wait a second, he has general equity jurisdiction, and he actually might have been able to get jurisdiction over a claim with respect to licensing. That one, it seems to me, is knotty. And by knotty, I mean K-N-O-T-T-Y. But your request for relief does not even ask for any relief with respect to the license.
Well,
your request for relief is to get the special permit.
Yes, Your Honor, but the complaint also asks in its general prayer for relief for such other relief as justice and equity may require. And here—
no, it has to be within the scope of your claims. If you sought to amend your complaint and said, I'm amending my complaint, And I'm asking that the court issue an injunction. I'm amending my claims, and I'm asking for certiorari to go to the Taunton City Council, directing them not to award the licenses until you've completed the review of the special permit under 40A. Then we would have had a different claim, and we would have fought out over whether that claim is within the jurisdiction of the land court, which you say yes under 185 1K. I say, tough argument, but I do understand it. All right. And that might be a different situation, but you didn't amend your claim. You didn't try to seek some sort of certiorari with respect to the licensing procedure. The court doesn't just have roving equity jurisdiction to quote unquote protect what it's doing. And that's at least not to my eye. Certainly wouldn't be the way I would have thought about it in 30-something years of practice. Let's put it that way.
The way this has been presented thus far, Your Honor, and the way the city has been interpreting it is you're not eligible to apply for a license until you have the special permit first. So we're not even available the way they are interpreting it and applying it to apply for a license. So what the land court was.
No, you could have taken that up as a separate claim for certiorari and said, look, you're interfering with my license, with my ability to get a license. And, there's a real question about whether you would have to file that in Superior Court rather than in the land court. And I understand your arguments in that regard.
If Your Honor feels that that's the correct course of action, then, we would ask for an opportunity to do that, Your Honor. If that's how you're interpreting this statute, that there isn't some open door to claim a right to a license, then we would do that. And the purpose being to allow the land court an opportunity to make a ruling so that.
I totally get what you're saying. I do, and I've been thinking about it for a few days, okay? I have another problem. Why do you need to enjoin all the licenses?
Well, Your Honor, as the lower court stated in its ruling, the city decided that they wanted to award all of the licenses in one fell swoop. How do we know that? How do I know that? Because in the supplemental record I filed, one of the things that the land court judge asked is for exactly what was happening. We filed in the supplemental record the agenda, and then the court asked for some clarification on whether the 5, I believe it was, pending applicants all had gotten a special permit, and when had they obtained the special permit.
Right, I saw that information, but that doesn't mean that the city was necessarily going to award all 4 licenses that day.
Well, that was what we understood, and I think that's what was represented to the land court as well in the lower court, Your Honor.
Let's assume you're right. I'm going to get to your brother on some of these questions, but let's assume you're right. Why would you get an injunction against all 4 in any event? Why is that an appropriate remedy for you, who can only get 1 license, to shut off all licensing by the city of Taunton?
Because if we need to have a seat at the table, Your Honor, and make our pitch that we're entitled to one of those, if the city council is going to look at it as a universe of where should these licenses be located within our city, if they, for example, were to look at one of the arguments in the lower court, Your Honor, was that notwithstanding traffic arguments, the city council had approved a.
How do I know you're entitled to a seat at the table?
If we get a special.
There's nothing in this ordinance that suggests you're entitled to a quote unquote seat at the table. I mean, if you had come along after 5 had already been awarded, tough luck, right?
Well, once we obtain a special permit, and if we've been wrongfully held up in getting the special permit, which is what we're arguing, Once we have that special permit, then we can apply for the license. That's how the city has interpreted it. So as soon as we get a special permit, we can apply for the license along with the other candidates and then be part of the
But why does it
discussion
have
of,
to be along with the other candidates? Why isn't it, if Taunton is allowed to award 2 more licenses, you can still get one of the last 2?
well, the representation, Your Honor, was they weren't going to do it that way. They had 4 left. They were going to hold a hearing. They had more than 4 applicants already, and they were going to award all of the remaining licenses. There would be none left. And also, Your Honor,
Yeah,
if
but
they,
that's not really an answer to my question. Hang on for a second. Counsel Gould,
Yes, Your Honor.
if this injunction, would the city of Taunton, given the choice between an injunction that says you can't award any and an injunction that says you can award all but 2 or all but 1, what would the city's view be?
We can award all but 1.
You'd be comfortable with an injunction. You'd be not comfortable. That's the wrong word. But I saw the argument in your brief where you said this is overbroad. We should at least be allowed to award some of the outstanding licenses, right?
That's right, Your Honor.
And is that the city's position?
Yes, even if there was, for some reason, there was jurisdiction, and back on that point, I do believe there's a process for a land court judge to go through to become a justice of the Superior Court.
That's correct.
But if there was jurisdiction, then 1 license being held for them would offer them that full and fair opportunity.
Yeah, I've been trying to figure out the math and the probabilities issue in my head, and I have to tell you that I don't know that only having 1 spot available is the same thing as having 2 spots available for purposes of a full and fair opportunity for Mr. Burke's client to get its license. It's a bit of a probabilities problem that I confess I probably worried about many years ago in college, but haven't thought about a lot since. And he points out that, that is influenced as well by the location of the licenses that are awarded. He may have a competitor across the street for all I know. I don't know about that.
that is, in fact, if I may interrupt, Your Honor, that is one of the concerns. There was evidence at the trial that another location within a quarter mile, which had more traffic than we were supposedly denied for traffic for, has gotten a special permit and is one of the ones that's applying. So if they're awarded a license for our section of town, if you will, then the city council could say, well, we don't need one at Basque's location because we've already got one nearby.
But you don't have any right not to have that happen. What you're claiming is simply a right to move forward with the application process and have that ability before decisions are made. And that's not a 40A issue. That's a licensing issue. All right, look, I think I understand the problem. And I'm gonna have to take it under advisement. I know I had one other question in mind, and it's escaping me at the moment. I apologize for that. So the issues that were tried, were you the 2 folks who tried the case in land court?
Yes, Your Honor.
And those issues, your argument is essentially the denial was arbitrary and capricious, right?
Yes, Your Honor.
And evidence closed in August?
Yes.
Yes, Your Honor. We submitted post-trial briefs in October, and that's when the court took the matter under advisement.
The post-trial briefs have only been in for a couple months then. I see. When in October?
I believe it's up. Actually, 1 second, Your Honor, I can give you that. It's referenced in the lower court decision, Your Honor, on the injunction. It was on October 9 of 2020.
I missed that. So he feels, well, strike that. I don't know how he feels. I haven't had a conversation with him or anything else, and I won't. But the fact that Taunton, in less than a month from the time that briefing went in, chose to schedule these hearings is part of the problem here, counsel.
Yes.
I'll say these hearings were scheduled to happen a year ago. They've been postponed every week, every month until now. And who knows if even if we had the hearing, if they would have issued any licenses or asked them for more information as they have for the past 12 months.
Okay, that's helpful. Thank you. You don't disagree with that, do you, Mr. Burke, that these have been scheduled off and on for a long time? So it's not like all of a sudden Taunton came along and scheduled them for November 4th when they hadn't been trying to schedule them for a long time.
I have no knowledge of that, Your Honor. For all we know is that nothing has been happening all through the trial, all through the post-trial period or through October 9. And then within a month later, they schedule this, and it appears from the agenda and the postings that they're going to award all of the licenses. And that's what I understood and what was represented, even to the land court, that was their intention. And it happens within a month of the post-trial submissions.
Did you have a hearing before the land court on the injunctive request?
We had a Zoom hearing, Your Honor, and that was the date of that was well, I let's see, believe it was in November, Your Honor. The judge issued his injunction the same within a couple of days of the hearing or a day of the hearing.
Attorney Gould, did you tell the judge that the intent of the Taunton City Council was to award all the licenses? There were 2 dates for hearings, right? Like the 4th and the 10th. Is that what we had?
Right. So it was a possibility that all the licenses could be issued. It was also possible that
Did you tell the judge that you expected all of them would be issued, or did you tell him it was a possibility?
Possibility. I'm not sure how much I speculated on the council's decision-making process. I do know it's a 2-step process, that it would go through the license committee and then go to the full council. So even if the license committee suggested to issue licenses, they would not be issued unless it went for a subsequent meeting.
Okay. You've both been extremely helpful. I'm going to take this matter under advisement. I'm going to reach a decision soon. I can tell you that it won't be today. I'm very, very, very busy right now, but I will try to do it as expeditiously as I can. And I thank you both for your advocacy.